Well, one of the most sensational and expensive defamation trials ever conducted in Australia comes to an end after 100 days of testimony. But I wonder what we've learned about, well, all sorts of different things. The military, litigation, the Australian psyche. Of course, we're talking about the defamation case brought by former Special Forces operator Ben Roberts-Smith. To talk to us about this, Alex Martin is a litigation specialist. He's the director of Taurus Legal Management. He's on the line with us. G'day, Alex.
Morning, Stephen. How are you?
Very well. The thing that I've gotten from this, and it generally is something that I think about whenever a high-profile defamation case comes about, and the Johnny Depp one is a classic example, is that you go to court to effectively or apparently defend your character and end up damaging your character in the process.
Yes, I think that's a very good point, and I think Ben Roberts-Smith, more than probably anyone else, has ended up in that category. You know, we've had Julian Morrow, we've had Christian Porter, we've had Peter Dutton, we've had Craig McLaughlin, we've had Rebel Wilson, we've had all sorts of high-profile people who've issued legal proceedings to defend their reputation, and I don't think any of them have ended up in a better position than they were when they started it, and certainly Ben, I think, has really damaged his reputation. This story's just gone on and on and on about him, and it certainly hurt him.
So obviously, the problem here is, though, if that is the message or the lesson that comes out of all these high-profile cases, it's going to discourage people from actually trying to defend their character and might embolden people to go out of their way to defame people. How do you find that balance?
Yes, well, that is a problem, and it's a concern from a litigation expert like myself. They've also introduced changes in the legislation recently which have capped the damages. So the damages are actually capped. The non-economic loss damages you're allowed to claim and capped at $443,000, which is less than they used to be, certainly before the Rebel Wilson case. So it means you can actually get that much money. I think the issue really is one about high-profile people. High-profile people are sort of in a different category than regular people, if you like, and certainly there's lots of cases where regular people, that's professionals, it might be doctors, lawyers, people where their reputation is important, accountants, have bought defamation proceedings very successfully and have got compensated for their loss and have defended their reputation and got the court orders they needed. And I think a lot of the time the cases that we hear about are the sort of unusual ones, I suppose.
Is there an argument to be made for having those proceedings conducted in a closed court? Because, I mean, particularly with this Ben Roberts-Smith case, he's suing media outlets, so there's a vested interest from the media outlets to expose this. I mean, and obviously the juicy details sell newspapers and get clicks on websites, etc. But it doesn't actually do any. There's no public interest in this, so to speak.
Well, yeah. So it's a matter of balancing the interest or the importance of having court being an open process against particular allegations that, if they were made public, might cause damage to the parties beyond what's reasonably necessary, I suppose. So that's a very tricky one. I think in this case it's reasonable to have it open, although the case has damaged his reputation, if you like. I think there is a real public interest in what the military is doing in Afghanistan. You know, if there's been allegations that someone's done the wrong thing, I think it's in the public interest that that be investigated and that people are able to hear what's happening in the court and people are able to have confidence that the court are looking into these issues.
The evidence in this trial has gone back and forward. I mean, some support Ben Roberts-Smith's version of events, others don't. But there's the old saying that in a courtroom, from a lawyer's perspective, never ask a question that you don't know the answer to. It could be said the same. It could be the same for a litigant.
Yes, absolutely. So that's the golden rule in litigation that I learned, I think, in the first case I ever ran many years ago. And it certainly does seem the case that on Ben Roberts-Smith's side, you know, that I don't think they were aware of the evidence that the soldiers were going to give. I mean, there were 19 current and former soldiers that gave evidence, and most of them gave evidence against Ben Roberts-Smith, effectively. Many of them said, I love Ben Roberts-Smith. Ben Roberts-Smith's an excellent soldier. One was even choked up in giving the evidence, but also said, although I love him, one said, I love him like a brother, but then they went on to say that they witnessed him killing an unarmed prisoner.
Yeah, it's interesting, the other issue I see with these things is that we're looking from the outside, and I mean you're obviously in a different position because you probably look closer at these things, but we don't know all the evidence that's been presented. We only see the juicy stuff that suits the media to portray. So I guess this cycle is going to start again once a verdict is reached.
Yes, that's right. So the judgment will be many, many pages long, and it'll probably make a whole lot of findings, and probably what will be reported is one or two statements from the judgment or one or two aspects of the judgment, and that happens all the time in all sorts of cases. You really get the sexy bits, if you like, of the case, and often it doesn't give a balanced picture of what happened in court, and it doesn't give a balanced picture of the evidence. And I'd encourage everyone who's listening and who's reading media reports about what happens in court just to remember that you're just getting the bits that the media think are interesting, and that the one-liners often. And you're really not getting a balanced picture of all of the evidence, which goes over many days.
So, Alex, in wrapping this up, if a person was to come to you as a lawyer and say, look, I want to commence defamation proceedings against A, B or C, what's the first piece of advice you give them?
Yes, so that does happen, and it's happened many times. The first issue is to get your facts straight. Work out who's going to say what the evidence is. Go and interview people. This is a case where there's a lot of verbal evidence, which is unusual. In a defamation case, you normally have a published bit of defamation, and that's it. But if there is verbal evidence, then go and talk to all the witnesses. And then you've got to put the litigation in context. So who are you fighting, and what's the commercial context this happens? In this case, we've got really two very large media conglomerates fighting it out. So it was always going to go to trial. It was always going to be a big deal. So the number one rule is make sure you get your evidence straight, and number two is to put it in context so you understand what you're trying to achieve, and if the litigation is actually going to achieve your commercial objectives.
Yeah, fascinating stuff. Alex, great to talk to you. Appreciate your time this morning.
Thanks, Stephen. Nice to talk to you.
All the best. Alex Martin, he's a litigation specialist and director of Taurus Legal Management. Let's have a look at sport with Bradley.
On 2CC Breakfast with Stephen Synergy and